No helmet, no compensation? Not necessarily. Here's what the law says. Florida law allows injured motorcyclists to recover damages even if they weren't wearing a helmet, but it can reduce the amount they receive. Insurance companies will try to argue that your injuries are your fault, and that's why having an experienced attorney is key. I'm Randall Austin, attorney for Marc Shapiro, and I'd like to be your attorney for these kinds of cases. Florida Statute 316-211, equipment for motorcycles and moped riders, states clearly a person may not operate or ride upon a motorcycle unless the person is properly wearing protective headgear securely fastened upon his or her head, which complies with the motor safety vehicle standards, okay? A person may not operate a motorcycle unless the person is wearing an eye protection device over his eyes, approved also by the department. And a person over 21 years of age may operate or ride a motorcycle without wearing protective headgear securely fastened upon his or her head if such person is covered by an insurance policy, providing for at least $10,000 in medical benefits for injuries occurred as a result of a crash while operating or riding the motorcycle. And kids under 16 could operate or ride a moped, but they must be wearing protective headgear. Now, sunglasses or prescription glasses alone usually do not meet the eye protection requirement. So in other words, you can obviously ride a motorcycle in Florida under the law with the $10,000 policy without a helmet. But does that mean when you're in an accident that the injuries you sustain to your head are going to be treated the same by the insurance company or a jury? No. It doesn't mean they'll be treated the same because you had a choice to make. So maybe your injury would have ended up being much less had you worn the helmet. And they're allowed to consider that. Of course, if you're in an accident and you're not wearing a helmet and you break your leg, that doesn't have anything to do with wearing a helmet, does it? So in other words, by law, you're supposed to do certain things, but those are basic traffic infraction type violations. But a jury is only to consider your injuries, and they're allowed to look at you helmet, no helmet, what could he have done, what would the injury have been had he worn a helmet, and what would it have been because you didn't wear a helmet. So basically, they're going to make the decision as to what your value is in your case and whether you recover the medical bills for your treatment. If you have a traumatic brain injury from an accident on a motorcycle that a helmet could have prevented, and trust me, the defense will have experts who will testify, medical doctors, specialists in TBI, and they will say things to the effect that, oh, this would have prevented it for sure. So it's up to you to make the decision, and it will have an impact, but it doesn't mean you can't make the claim. Thank you. I'm Randall Austin again with Marc Shapiro, PA. If you want to get in touch with us, please reach out to us on our website or give us a call. Look forward to hearing from you.